A Catholic couple in Massachusetts went to great lengths to be ready to be foster parents, but the state denied their application. The reason was their religious faith.
They wouldn't be placed with the Burkes either because the Burkes are completely excluded from fostering any child because of this, like you said, hypothetical situation where they may not be as affirming as some of the state officials at least seem to feel they needed to be.
On this episode, we're diving into why the state of Massachusetts believed that Mike and Kitty Burke's religious faith disqualified them from becoming foster parents, and how that decision runs afoul of legal precedent, religious freedom, and the needs of children. You're listening to Defending Ideas. Defending Ideas is a weekly podcast produced by Sutherland Institute. On this show, we are committed to renewing the principles of common sense conservatism, making you a better champion of sound ideas. Welcome back to another episode of Defending Ideas. Thanks so much for joining us. I'm Nick Dunn, your host, and our topic this week is a Catholic couple in Massachusetts whose request to become foster parents was denied by the state on account of their religious faith. And our guest returning to the show is Bill Duncan. He's our Religious Freedom Policy Fellow here at Sutherland Institute and our resident expert on all things constitutional and legal. And Bill, it's so great to have you back on Defending Ideas.
Thanks for having me.
I want to jump into this case and give folks kind of a sense of the facts of the case, what are the legal issues at play, what could happen moving forward. But before we get into all that, I wonder if you could just help tell the story of the Burkes.
Sure.
Who are they? What's their background? What brought them to this point now?
Yeah. The Burkes are a really exemplary couples, according to all we can understand from the case. They are a Catholic couple involved in their parish, but also involved in all kinds of good things. Mr. Burke is a Iraq war veteran. They've had challenges with health and mental health, and that's been kind of a source of resilience for them. They've overcome some challenges, and so in a lot of ways, it just seemed like exactly the kind of people you'd want to have in the system helping children, because they're motivated to do that. They're warm. They're good people. They have a lot of background that would bring resources that maybe other families might not have.
There's something that stands out about their life trajectory, their life history. It seems to be focused on serving and giving.
Right.
And in this case, especially, they're kind of that desire to serve through a parental role. They wanted to become parents, that they struggled with infertility, which kind of led them to now this question of, well, maybe we should adopt or become foster parents.
Yeah, exactly. In fact, in some ways, they're not focused on being foster parents initially. They want to adopt. It's as people who've been involved in that process know, it can be expensive. And as they're going through the process, learning, trying to prepare to be good parents, if that opportunity arose for them, someone else mentioned to them, hey, yeah, I think you'd be great foster parents. So other people recognize this is the kind of people we want to have helping children in the system.
And remind us kind of as far as how the process works in Massachusetts, and there are some similarities here in Utah and other states, but there's a pretty thorough both vetting and training process before you can get to the point where it's kind of that final up or down vote, the state saying, yes, we want to treat you as a foster parent couple where we can place kids with you or not. Can you help us understand what does that process look like before they can get to this point even?
Right. Well, in a lot of ways, we don't regulate parenting a lot. We leave parents alone, which is a good process. But what's unique about foster care is the state is responsible for these children. The children are kind of theoretically the children of the state because they're being removed from their biological parents or for whatever reason. And so the state's going to be really careful, correctly so, to ensure that these children aren't going to be harmed by someone, that they're going to be in the best circumstance. And their situation is going to have increased vulnerability for the children. Ideally, the children are able to get back with their parents and live with them again. So you want a couple that's going to facilitate that. But they may also want to be adopted. So ideally, the couple's open to that as well so that they can have a permanent home if that becomes available. So yeah, there's lots of training that goes on. There is vetting, there's home studies, there's interviews. The state is trying to do everything possible to ensure that not only is this a good couple, but they have the right motives for what they're doing. They're not trying to, have any kind of financial reason or worse. And that's the process that the Burkes went through here. Lots of training, lots of learning. And they would the facts of the case indicate they went the extra mile in terms of that process, making extra efforts to learn how they could be good parents, what the foster care system is like, what kinds of vulnerabilities children that might be in their care would have.
The other thing that's, I think, striking and worth reminding folks of how open the Burkes are to a number of different circumstances. You kind of mentioned that, being open to taking siblings, being open to foster with the goal of reunification. And I've seen folks close to me serve as foster parents where they experience that. And it's kind of a tough circumstance sometimes. Lots of tough issues they're dealing with, and being open to kids with special needs. So it kind of seemed like in so many different respects, they were saying, look, we will take any child who needs a home. Is that a fair summary?
Yeah, and in fact, the only other thing I'd add is they were willing to take groups of children, right? Siblings, if that was necessary, to allow those children to still have that additional layer of stability to be with their siblings. So that's right. They went to great effort to be open and willing to do some difficult things. So that kind of brings us up to speed to today. That a lawsuit was recently filed. Can you walk us through kind of what are the facts of the case? The Burkes, in their claims against the state of Massachusetts, help us just understand on what grounds their lawsuit is resting. Just walk us through some of those facts. Well, as you kind of described, maybe I'll just add some details. The Burkes had been approved to be adoptive parents. That was the route they initially had gone down. But because of the expense of a private adoption, that didn't seem feasible for them. Someone suggests to them, foster care is a good idea. They look into that, and they go through more than a year process of learning, being vetted, to determine if they would be good foster parents. Some of the questions during that process of vetting dealt with their religion, their religious beliefs, and specifically religious beliefs about marriage and sexuality. And the questions, reasonable questions, had to do, well, what if there's a child that's placed with you that is LGBT, and what is that going to, would you be able to handle that? And the Burkes say, we're going to love any child that comes in. We're going to be supportive. We're going to help them. Of course, we have religious beliefs, and we're going to teach them what we believe is right in terms of what their behavior should be. But we'll be loving. We'll be positive, in that setting, and left it at that, which I think is what most of us would think the right answer would be in a circumstance like that. But that wasn't exactly what happened in this case. In fact, even though in the report on the Burkes that the state child welfare officials gave, they recognized this is a couple that's unusually knowledgeable about the process. There's so many positive things about them. They decided to deny their license to be to be foster parents precisely on this grounds, that they said, well, because of their religious beliefs, they wouldn't be affirming to a child that's placed with them that is LGBT, and so as a result of that, they're not approved to foster. Of course, recognizing that's not a valid reason to deny someone a ability to volunteer in the system. They have some excellent attorneys from Beckett Law, a religious liberty law firm, and they've now brought a lawsuit to correct that misunderstanding of the law that seems to be evident in the decision of the Massachusetts officials.
I want to clarify two quick things in there. So essentially, the Burkes' response was, when the state asked, okay, well, what if a child or a number of children are placed with you and their gender identity or sexual orientation, comes up to be something that's in conflict with your religious beliefs? What do you do then? Notably, the response was not, well, we'd kick them out of the house. Right. That would be wrong. That would be horrible. Yeah. That's not what they said. They said, no, that we're going to love them and welcome them no matter what, but we still have our religious beliefs. Those are the things that we believe. So I think that first clarification is important. And then secondly, my understanding, at least, Bill, is that this was not a series of questions oriented towards, hey, we have specific children or specific youth that have an LGBT identity of some kind. So it's not vetting the Burkes specifically for those specific kids. It's sort of hypothetical future cases that in general, if something like this came up. So is the state of Massachusetts saying, because of their response on this issue, that they'd be welcoming and loving but would still hold to their religious beliefs, it's kind of just a categorical denial rather than maybe some kids might be a better fit for different homes.
Right. That's exactly right. And it's reasonable for the state to look on a specific circumstance and say, well, given the background of this child or their family circumstances or their goals, we'll place in different places. That makes good sense. But that's not what's happening here. Imagine imagine a child that comes into the foster care system in Massachusetts that comes from a very traditional Catholic background, and maybe once that's a source of strength and resilience to them. They wouldn't be placed with the Burkes either, because the Burkes are completely excluded from fostering any child because of this, like you said, hypothetical situation where they may not be as affirming as some of the state officials at least seem to feel they needed to be.
You wrote recently an opinion piece for the Washington Examiner, and you get into this issue, and I want to read a quick excerpt where you identify some of the data points that, according to some of the recently available data, shows that close to 400,000 children across the U.S. are living in foster care. And then in Massachusetts specifically, the number is well over 7,000, close to 8,000. Again, this is for kind of the most recent data available. Given those numbers, how would you describe kind of what you've seen as you've been digging into this case? Does it seem like it's crisis level? Is that a little bit too dramatic of language to describe what's going on in Massachusetts specifically with respect to the number of kids in foster care?
Yeah, one of the statistics I don't mention in the article, but that came out is if you think you've got 7,000 children in foster care, you've got 5,000 approved foster parents. Well, I'm not good at math, but you can see there's an imbalance there. And in fact, there are some news articles from Massachusetts that show that there are some children who are living in hospitals, taking up rooms or beds in hospitals because they don't have a place to go. So, I don't know how long that's happening, and obviously there's even more serious circumstances that exist. But Massachusetts, like many states, this is a serious concern. These children are not getting what they need, and everyone knows that for in a child's life, their time horizon is a little different for adults. We sometimes think of children as being resilient, but I'm not sure that's always exactly right. That this is a big portion of their life they're spending in perhaps institutional care, perhaps homes that are not ideal for them. So from each child's perspective, it actually is a crisis.
But we have to take a quick break. But when we come back, I want to get into kind of the legal precedent that in your piece for the Examiner, you say that, look, Massachusetts is probably not on solid legal footing in terms of their denial of the Burkes. So I want to get into some of those examples. We're going to take a quick break. You're listening to Defending Ideas. We'll be right back.
Sutherland Institute is an independent, nonprofit public policy think tank based in Salt Lake City, Utah. Our mission is to defend the principles of the American founding and strengthen the institutions of civil society essential for those principles to endure. Sutherland provides research, events, and multimedia to policymakers and the public to promote the principles of faith, family, freedom, opportunity, and responsibility. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. On this podcast, we're dedicated to renewing the principles of common sense conservatism. I'm your host, Nick Dunn, and we've been talking this week with Bill Duncan. He's the Religious Freedom Policy Fellow here at Sutherland Institute and our resident expert on things to do with the court and the law. We've been talking about the case of a Massachusetts couple who was Catholic and denied their application to the state to become foster parents on account of their religious faith. We're going to get into some of the details of legal precedent that might shed some light on how their suit will move forward. But before we do that, I want to mention, if you like what you're hearing today, please visit us at defendingideas.org. You can find short clips from this episode that you can share on social media and use in conversations with friends and family. You can also subscribe to the podcast on Google, Apple, Spotify, any of the major platforms, wherever you like to get your shows. You can also subscribe to this podcast on YouTube if you prefer to watch our full episodes there. That's defendingideas.org. Bill, I want to continue where we left off and give folks a sense of the legal precedent. This is not happening in a vacuum. There are a number of other cases, both at a U.S. Supreme Court level and then some lower federal courts, dealing with similar issues. So can you walk us through some of those examples so we can see how it might be applicable to this case?
Of course, it's good to remember that there are cases on the, it's one thing for the state to kind of be stumbling around and trying to figure out the right way to approach a new issue, but this is not a new issue. In 2020, the U.S. Supreme Court issued a ruling in a case that involved Pennsylvania Catholic Charities. And in that case, the city of Philadelphia said, look, the Catholic Charities can't be involved in the foster care system, helping children in foster care to have connections with foster parents if they aren't willing to affirm the state's definition of marriage as, any two people. And of course, the Catholic Charities wanted to keep their own mission, which was to promote marriage and as opposed to, say, unmarried relationships and other things. The Supreme Court said in that case that the Catholic Charities has to be allowed to participate if the only reason they're being excluded is because of their beliefs. That violates the First Amendment. Because we all have the ability, we all have the right to practice our religion, and we shouldn't be discriminated against because of doing that. That's not to say that everyone has a right to be a foster parent. Some people will be good foster parents, some will be bad. The state can use all kinds of reasonable criteria for maybe screening someone out of the process. They're not capable of taking care of children. They don't like children, whatever the reasons are. Those people can be excluded. But if the only reason we're excluding them is a protected right that they have, which is to have and practice their beliefs, that would be wrong. And what's important, I think, to note is that it's not just that U.S. Supreme Court decision, but there are lower court decisions, which I think suggests that other courts have recognized this principle that the state of Massachusetts seems not to be applying in this case. So, for instance, there's a case that went all the way up to the Court of Appeals in the federal system from New Jersey. And in that case, the court said you can't punish a couple for sharing their beliefs about marriage with a foster child. And then there's a case in Washington involved some grandparents who wanted to foster their children, but the state excluded them because they had religious beliefs about marriage and sexuality that the state felt would not be appropriate for a child. Again, these people would be qualified in every other way except for their religious belief. And that's the situation with the Burkes too. So in law, we like to think, if you're looking at a previous decision and see if it's relevant, how close is it to this one? Well, those decisions are pretty close to this situation. So I think Massachusetts could have known that they were treading into sort of a territory they shouldn't be in treating religious beliefs different from other kinds of beliefs. Or
I think just to clarify the comparison, these are instances in the other court cases you mentioned, either organizationally, other groups that in perhaps every other respect are well qualified to provide various services. And in this case, a couple, in the specific case, the Burkes, in every other respect, very well qualified to provide services, in this case, fostering for kids. But that one thing, that religious faith being the difference, is kind of what you're saying. The legal precedent is saying, well, no, that cannot be the reason you deny a person or an organization.
Yeah, that's exactly right. You said it better than I did, but that's right. That's the concern here.
Just I can hear the critics or the naysayers in my head saying, okay, well, does that mean every religious belief? If somebody for some reason had what they felt was a closely held religious belief to deny food or clothing to children or something bizarre and that would, of course, constitute an abusive situation or a neglectful situation, how would the law draw the distinction to say that, okay, when we're talking about religious beliefs that maybe would not in another circumstance be considered abusive or neglectful, kind of help us figure out that line that, religious beliefs in this category cannot be disqualifying, but that doesn't mean that every belief under the sun would not maybe present a reason to disqualify somebody.
Yeah, that's exactly right. What we want to look at in a situation like this particular one, especially when foster care is highly regulated by the state, and the state has all kinds of good reasons for looking very carefully into who will be foster parents. We want to determine why they're making the decision they do. And if the state comes across someone who believes that hitting children is okay or something, of course that's rationally related. It's even compelling for the government to prevent a child from being placed in a home like that. In this case, we have the exact opposite. We have everything that leads us to believe this is kind of an ideal couple for the children who would be in foster care. And unrelated to their qualifications to serve, then we're tacking on this additional criteria. But do they have religious beliefs that kind of are at odds with the state's kind of ideological commitments? That's where you go too far. And this is a common in religious freedom cases. Of course, we want to know if a person is using a substance in a religious ceremony. We might say, well, that's fine, they can do that, but they can't drive. As long as it's relevant to the circumstance. Here, there's no evidence that's relevant at all. In fact, just the opposite, and that's why this raises so many constitutional concerns.
I want to read a quick excerpt from your Washington Examiner piece that we'll include the link in the show notes for this episode as well. But I think it articulates well this idea of a core grounding principle that is derived from some of these other cases, the Supreme Court and the lower court rulings on similar cases. They can give us a principle that we should ideally be able to apply evenly across this case and other similar cases. So this quick paragraph from your piece that I thought captured this perfectly. You write, "The Burkes exemplify the ways that religious faith motivates people to give to those around them. That contribution cannot be made if states unfairly screen out, for narrow ideological reasons, the people who seek to help because of the very characteristic that motivates them." Is there anything you would add to that? Is that kind of the principle encapsulated that then we should apply to this and other cases?
That's exactly right. And I think there's an irony here because when you think about it, I think the state of Massachusetts is sincerely concerned for the welfare of children who have to be separated from their parents for a time. That's a tragic situation. But they've got a great resource here. In fact, the case makes clear that the state of Massachusetts actually uses religious organizations to recruit parents into the foster care system. So they're adding this new category on of expressing a concern, but it's precisely the thing that makes these parents so good, and others like them. I don't know if you want me to say more about kind of the role of religion in foster care, but from a legal point of view, this is exactly the problem.
We'll go ahead and give our listeners a little bit of that religious faith, yes, it is not a valid reason to disqualify a foster parent couple, but also it does a lot of good in the space of taking care of kids and fostering and adoption. And can you talk a little bit about that, of how essentially to bolster the idea that religious faith not only should not be excluded as a motivating factor for parents or organizations, it ought to be welcomed because it does a tremendous amount of good. And imagine all of the good done in our communities that would not happen at all if religious faith, either individually or organizationally, was increasingly sidelined when it came to serving those in need.
Yeah. As a matter of law, this is a relatively easy case because there's a constitutional violation. But in addition to that, and it's important to think, why does the Constitution protect religion so much? It's exactly for this reason, among others. We learned some time ago, as we were trying to learn more about the role of religion in the foster care system, we had an interview with a scholar, Naomi Schaefer-Riley, who wrote a great, responded to some questions we asked. And she said, religion is the bright spot in the foster care system. Religious organizations, religious people, they not only are they more likely to be foster parents, but the amount of time that a child spends in foster care with a particular couple is greater if the couple is religious. That's positive because it gives some stability to the child. There's all kinds of ways in which religious motivations lead people to want to do things like provide foster care that they wouldn't do just because they think it's a good financial investment or something like that. We need that. We need people to be motivated by more than money, by more than force, by other things. So when someone comes forward and says, okay, well, I feel because of my beliefs that I want to help children in need, and I tried to qualify myself to do that, and there's no other reason to think they wouldn't do a great job, the last thing we want to do is to say, well, actually, that motivation is what keeps you from being qualified as a foster parent. Rather, we should be encouraging that, and a lot more parents like that could potentially come forward and provide a service that's not being provided otherwise.
Well, we have to take another quick break, but when we come back, I want to kind of talk about what's next. What's next for the Burkes? Where does this case go from here? What's next for the state of Massachusetts and other states? Should other states be paying attention either through the legal framework or through their state legislatures, and maybe also get into what things have been done here in Utah, or maybe the state of Utah is a little bit ahead of the game with respect to protecting religious freedom in state law. So we'll get into more of that. Our guest is Bill Duncan, our Religious Freedom Policy Fellow here at Sutherland Institute. You're listening to Defending Ideas. We'll be right back.
For a deeper dive into the issues you care about, read Sutherland Institute's official blog, Insights and Takeaways. You'll gain deep insights from policy experts and relevant takeaways voters need to know. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. I'm your host, Nick Dunn, and this week's topic is a Massachusetts Catholic couple who was denied the ability to become foster parents on account of their religious faith. We've been talking with Bill Duncan, the Religious Freedom Policy Fellow here at Sutherland Institute, about the case and what it should mean for religious freedom protections for other states. Before we continue, though, I want to point out, if you like what you're hearing today, please visit us at defendingideas.org. You can find short clips from this conversation, as well as previous episodes, that you can share on social media and use in conversations with your friends and family about these issues. You can also subscribe to Defending Ideas on Google, Apple, Spotify, essentially any of the major podcast platforms, wherever you like to get your shows. That's defendingideas.org. Bill, I want to pick up where we left off and essentially help answer for folks, okay, what's next? The lawsuit has been filed. The Burkes have made their claims saying that it was inappropriate for the state of Massachusetts to deny their application to become foster parents on the grounds of their religious faith. So for the Burkes, for this case, where does it go from here?
Well, ideally, the state recognizes they've blown it, and they can offer to the Burkes to allow them to be licensed and move forward and fix the problem. But the typical process is they'll sue. They've sued in federal court. A trial court will either make a decision or feel like, well, the facts are pretty obvious. We can just decide how the law applies, which I think is very likely. And then either side, if they don't like that lower court opinion, can appeal to the U.S. Court of Appeals. If the U.S. Court of Appeals rules, the U.S. Court of Appeals rules one of the sides may not like that decision, they can ask the United States Supreme Court to weigh in. I'm hopeful that won't be necessary, that either the state will recognize early on that they're better off having a great couple like the Burkes participating in the system, or that the courts will rule in favor of them and it'll be settled at that point. But that's the normal process.
So taking it for a brief moment out of the judicial realm, you've articulated well that the lower courts or the state court, those entities should rule in favor of the Burkes for the reasons that we've been talking about for this entire episode. What about state law? Is there state legislation that maybe state leaders in Massachusetts ought to look to?
Absolutely. In a lot of ways, the First Amendment is pretty clear. You can't discriminate against a person just because they're trying to exercise their right to practice their religion. That makes sense, I think, to almost everybody. But usually that comes up in the context of cases and lawsuits like this. But the states really ought to look at opportunities to avoid these kinds of conflicts, either by not imposing restrictions like this, or by, even better, acting to diffuse the conflict before it arises. In Utah, we've done some, I think, really positive things along those lines, looking at things that might happen. Just to take one simple example, what about a student who wants to wear a religious, headwear or something while they're involved in high school athletics? We've said, well, they're free to do that. The state should accommodate that. And I don't know why the state of Massachusetts and many other states couldn't do a similar thing. It's just a very simple line in the law that says you can't discriminate against a person in foster care licensing based on their religious belief. In fact, arguably that the state does already do that in Massachusetts and could just enforce that. But I think that it's wise looking forward for legislators to say, let's not just wait for the courts to have to backstop us every time we make mistakes. Let's affirmatively clarify what rights religious people and others have in acting on their beliefs and acting on their conscience, and ensure that they can do that without any interference.
I want to draw a connection with this and what in many ways is an ongoing theme for Defending Ideas and the issue of polarization, because it feels like so many of our political and policy disagreements are highly polarized. It seems like the stakes are really high, the issue is really important, and it kind of feels like this do-or-die mentality, kind of a zero-sum game. And in a previous episode, we talked about that with another one of our policy fellows in the context of education, and how when we increasingly push education issues up to the federal level, the national level, that helps to fuel the fire of polarization. And I think it's the same with legal issues. When we increasingly push these sometimes complex and important issues dealing with the law and competing rights, when those are left only to the court system, and they sometimes inevitably wind up before the U.S. Supreme Court, it feels like there's a lot on the line. It's a big national debate. There's a lot of controversy and attention around U.S. Supreme Court cases when they come out. And with respect to the important role the judicial branch plays in adjudicating those kinds of conflicts, it sounds like what you're saying is, hey, guys, there's a better approach. Let's get ahead of these fights and let's have these discussions in legislation. Why is that, in many cases, maybe a better way to address some of these religious freedom conflicts through the legislative process rather than through lawsuits?
Well, as a principled matter, all of those officials, legislators, administrative agency, all of them are bound to obey the U.S. Constitution. So they should look at their actions and say, is this likely to violate the Constitution, and so avoid that. As a matter of principle, that's one point. But I think as well, it's worth thinking that if we really want to promote a pluralistic kind of living together peacefully, we can see potential conflicts that are likely to rise and diffuse them before they even happen. If we don't do that, of course, the stakes continue to get higher, the tensions increase. But part of the problem is that couples like the Burkes. The Burkes are represented by a great law firm that's willing to make the effort to help them. But how many other people they just say, oh, I guess I'm not allowed to participate in this system because I have strong religious beliefs, and even though I'd like to help kids, I can't do it. They're excluded without even a peep, or at least one that we hear of. So that's a serious problem, and it wastes the money of the government and of individuals when they have to fight these things out in court, when they could much more easily just resolve it before it even occurs.
You mentioned pluralism, and let's apply that to this briefly, because I think there's one of the undercurrents in so many of our debates as a country over religious freedom. It seems to me that a misread, or rather a limited understanding of religious freedom, might go something like this, to say that, well, if no one's stopping you from going to church on Sunday or your chosen observance day, and no one's coming into your homes to stop you from praying or reading your religious texts, religious freedom is totally protected. Quit complaining, everything's fine. But the misread is that religious faith is not only something that people find value in when they worship for a couple hours a week, or when they pray, or when they read religious texts. It's something that informs and impacts their day-to-day life. And perhaps you could say that for people who are the best examples of religious adherence to a faith tradition, it is something that, if it motivates me to be a better person, to serve others. You mentioned in your piece for the Examiner how impactful that is. I want to read another excerpt where you say, quote, people of faith are significantly more likely to consider fostering. Foster parents reported that faith/church support was one of the top 3 factors in successful fostering. And so religious faith, if it's relegated only to essentially a meditation practice that makes you feel good, that's not what faith is actually all about. It's supposed to impact people's lives for the better. And that's manifested by folks being motivated to serve others in the case of foster parents. So help us understand that why this case, it's not just about the Burkes, it's not just about Massachusetts. It's about this underlying principle that it's okay, in fact, good for religious faith to motivate people in many aspects of life, both private and public.
Well, the First Amendment establishes that principle. It's not just about a right to worship, like the Soviet Union had a supposed right to worship in their constitution. It didn't mean much. Our Constitution says that we can't interfere with a person's right to practice their beliefs. And I think that the founders knew something that we might lose a little bit of touch with now, and that is that people who feel accountable to God, to a higher power for their decisions, often make decisions that benefit not only them, but many others as well. And there'll be a whole range. There'll be pluralism is plural. There are people who say, gosh, I'm not sure I'd want to foster a child who's traditionally religious because I don't believe that way. That's okay. If they're willing to participate in the system and make a difference, that's great. But both history, just common sense tells us that people who have a strong religious belief shouldn't be treated as sort of second-class citizens in the system. That's not just good policy. It's what's required for us by the Constitution. And the degree that we make that kind of well-established principle, I think we welcome not only religious voices, but many other voices as well into the public discussion and into maybe more than just voices, actual actions to help others in our communities.
As we round out this discussion, we're almost out of time, but I wanted to bring things back to you. You mentioned briefly the state of Utah and maybe some of the areas where here we're maybe a little bit proactive or ahead of the curve on doing things through legislation. You mentioned, I think school uniforms and athletic dress with respect to religious belief. Are there any other examples you want to point our listeners to that here's some of the things that Utah has done through legislation that prevents some of these legal fights that become very contentious and protects religious belief and maybe balances important rights in a way that fosters that kind of pluralism you're talking about under the Constitution?
Absolutely. In fact, just this last legislative session, so the beginning of this year, the legislature considered a bill about adoption that would ensure, on the one hand, that anybody who comes in and says, I'd like to adopt and participate in that system, again, assuming that they pass the normal, checks and everything that would be necessary, that they can do that, but also allowing religious organizations or faith-based organizations to place in accordance with their mission. Those things don't have to be mutually exclusive. We can allow lots of different people with lots of different beliefs and ideas if they're otherwise qualified to participate in these important enterprises like caring for children. Right? This is among the most important. And Utah's done, I think, a good job of being sensitive to that and noticing that before it happens. Other states are doing a good job on some of these things as well. It's not a partisan issue. Illinois, Washington, they've done some good things along these lines as well. But I think many legislators should be looking at ways to see conflicts that may arise, diffuse them before they even happen. That allows many more people to be involved and to feel that their views and their beliefs are respected.
Bill, last question before we close. What is the likelihood that this becomes one of the big contentious cases before the U.S. Supreme Court? Are we going to be talking about this next June as far as, hey, the court ruled in this way on another big religious freedom issue?
I hope not. I think what the Supreme Court would like to have happen, I'm speaking for them, but just assuming is that they would like for the lower courts to recognize they've established a principle. We don't discriminate against religious people or because of their beliefs, and to act on that, to just allow that to be the principle that governs every state, so that these conflicts don't arise in the future. So I'm hopeful that that's what happened. There is a possibility the state might sort of dig in its heels and continue to fight, but boy, that would be so short-sighted given the great opportunity they have to have a couple, and I'm sure there are others like them, who, motivated by their faith, their feeling of accountability to God, want to help some of the most vulnerable in our society.
Well, we'll leave it there. Sounds like the state of Massachusetts, as well as other states, have some things they could learn from Utah and from Bill Duncan. Thanks so much for joining us on Defending Ideas, Bill.
Thanks so much for having me.
We'll be right back. We're going to take one final break before we leave you with some final talking points to help round out this issue. You're listening to Defending Ideas. We'll be right back.
Sometimes it's hard to keep up with the latest policy debate that affects your life. The solution? Subscribe to Sutherland Institute's weekly newsletter, where you'll find in-depth insights from seasoned policy experts, compelling multimedia, and advance notice of special events. Visit sutherlandinstitute.org. Welcome
back to Defending Ideas. Before we go, just a few quick talking points. If you find yourself in the conversation with somebody who might be inclined to support what the state of Massachusetts did in this case, or someone who might in general express some misgivings about the role that religious faith plays in social services, here are a few things that you can consider sharing. Number one, articulate that there is a very serious need for more foster parents, not less, not just in Massachusetts, but all across the United States. The numbers are pretty staggering that countless children that are in the foster care system would benefit from a loving home environment and deserve to be placed in homes that would provide that loving care that could be provided by a number of potential future foster parents. Number two, articulate that the Constitution, as well as legal precedent, requires that the state cannot discriminate against people or organizations solely on the basis of religious faith. Number three, religiously motivated people and organizations do a tremendous amount of good in our society in a whole range of social services, feeding the homeless, education, caring for children, healthcare. There are so many things that are accomplished by faith-based groups and people. And to recognize this is to support the idea of pluralism, that we can have many organizations and people motivated by the right intentions to try to help and make a difference in our society. That also means that religiously motivated people and organizations should not be sidelined by the state or by the law. In fact, they should be welcomed and even protected under the law because of the valuable contributions that they make. We hope that you've enjoyed this episode and that these principles help you to feel better empowered to defend the ideas we talked about today. If you like what you heard, please visit us at defendingideas.org. You can find short clips from this episode and others that you can share on social media and use in your conversations with friends and family about these issues. We also encourage you to subscribe to the podcast on Google, Apple, Spotify, essentially any of the major platforms wherever you like to get your shows. If you're watching us on YouTube, please subscribe to our YouTube channel. And lastly, if you want to support the work of Sutherland Institute, please visit sutherlandinstitute.org/donate. Thanks so much for joining us on Defending Ideas from Sutherland Institute in Salt Lake City. I'm Nick Dunn. We'll see you next time.